Oh, well, but again, in Denmark, I can't go to the hospital now and say, hey, I just had a problem working my arm. They'll send me to my doctor on Monday.
2 hours away from the Expo, Bank of America Boston Marathon Expo, opening up at the Heinz Convention Center. And we're just 1 hour away from our Bank of America Professional Athlete Press Conference, which will occur in this very same room in an hour. And you are all invited to stay and come back for that press conference as well. Our theme this year is History in the Making. We're celebrating the 100th anniversary.
First, so in reviewing the motions in limine, I mean, clearly the defendant has an absolute right, a constitutional right, to present a third-party culprit defense, but counsel is well aware that that is not without limit, right, from the case law. Now, the defendant has stood here, defense counsel has stood in this court repeatedly, stood here and in other venues and in their pleadings, espousing various third-party culprit theories or scenarios. But now that it's time to actually try the case in the courtroom, I don't have a motion from the defense to admit third-party culprit testimony. So, and as you're well aware, I have to make findings before any mention of any third-party culprit evidence or even an opening goes before the jurors. In order to admit it, given that I have no information at all, I mean, I don't know who the third-party culprit is, even after reading 4,500 pages of discovery. I don't know what motive a third-party culprit might have. I don't know how it's relevant. I don't know if it's remote or if it's current. I don't know if it's speculative or if it's relevant. I don't know if it will prejudice or confuse the jury. And if it's hearsay, I have a whole other series of factors I have to consider. So, Mr. Yannetti, are you pursuing a third-party culprit defense?
We are, Your Honor, and I'm prepared to address that. The Commonwealth has raised the issue, and I am prepared to address that today.
So you filed your motions first, and you did not raise it. So if the Commonwealth had not raised it, you did not move to introduce it, correct? I have no motion from
No, I
from
understand.
you about it.
I understand, Your Honor. If you'd like something in writing for us, we can do that. I have a full argument prepared.
All right, so who is the third-party culprit?
We are under no obligation to name any specific third-party culprit.
All rise, please. Yea. All persons have entered before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court in the County of Norfolk. Do I need to give your attendance and shall be heard? God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Thanks, Jim.
Judge, this is 22 CR 117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Adam Lally for the
Good
Commonwealth.
morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Tanis Yannetti representing Karen Reed.
Good morning, Ms. Yannetti. I'm told that David Yannetti's held on trial somewhere else.
He is, Your Honor.
Okay. And good morning, Ms. Reed. All right. So first and foremost, housekeeping. Mr. Lally, what is the status of the DNA?
So, Your Honor, the status of the DNA is I spoke to the lab a few times over the last couple of days. They actually were able to stay late last night and finish the mitochondrial portion in regard to seeing if they were able to generate a profile from the hair sample.
Can you hear him, Ms. Yannetti?
I would actually prefer, Your Honor, if you would take the
Or
podium.
just,
Fine.
yeah.
So, Your Honor, just to begin again, so I've spoken to the lab a few times over the last week or so, including this morning. So they were able to stay late last night and finish generating to see if they could generate a mitochondrial DNA profile for the hair sample. I was informed this morning that they were able to generate a partial profile. They're still in the process of seeing if full profile can be generated, but they've begun the process of generating a profile from the sample from Mr. O'Keefe. As far as I'm a little unclear, and I responded with some questions just for clarification purposes, because I'm a little unclear of whether or not a partial profile would be something they could do a comparison with in regard to the mtDNA. And then I'm also inquiring as to, so initially what I've been told is that if they were not able to generate a profile, I would have a report on that by the end of next week, and that would essentially be the end of it. However, given this development, I'm not sure, other than they indicated that any sort of report regarding a comparison would likely be sometime after April 16th. And then obviously I asked for clarification, and I'm still waiting that as far as what after April 16th means, as far as are we talking about, you know, the week following or a month later, or what the situation is. So unfortunately, I don't have a ton of clarity, but at least I'm able to tell the court that they were able to generate at least a partial profile from the hair sample.
All right, so trial starts a week from Tuesday. I would entertain a motion to exclude the DNA. All right, so let's move on to what we
Understood.
have here. All right, so I will hear from the Commonwealth on your
Hey, Mary
motion
B.
for a buffer zone and for restricting clothing.
I forgot to share this yesterday in Discord, so I didn't know if anyone would show up, but I want to get through these, and that's why I did this. You know, if no one was here, at least I get through these, and if anyone wants to go back and watch, it would work, you know, work out. Because I want to get to the, I want to get to pretrial motions. So it doesn't look like there's, or get to, oh my God, I am too tired today. I want to get to opening statements.
Thank you, Your Honor. So the Commonwealth would ask that the motion be allowed for a number of different reasons. Essentially, what I would submit to the court is that this is not, as the court is well aware, this is not a novel approach. This is something that's been done in other cases and done specifically in other cases in this courthouse. What the Commonwealth would submit is what's been proposed to the court is an entirely neutral motion, and that it applies equally regardless of viewpoint, regardless of, you know, content of signage or clothing items or anything else. The motion the Commonwealth filed is not in essence about any sort of protesters or any sort of presence in regard to them, but more about the jurors and about the jurors' freedom to be free and to come and perform their civic duty free from extraneous influence. We need in this case, obviously, as the court is well aware, a fair and impartial jury. And this is something that extends beyond just the impanelment of that jury. As the court is well aware, as the court asks questions or inquires of every jury in every case multiple times a day about whether or not that they've been exposed to any sort of extraneous influences, or if they've gone online, or if they've seen things on social media pertaining to the case. And question I would ask is, how is a juror supposed to truthfully answer that in the negative when they're bombarded with it every single time that they walk in and out of this courthouse? It's not asking for a restriction on free speech or to infringe upon someone's First Amendment right. Protesting is going to happen. That's fine. It's just where it happens and how it impacts the jury in this case is what the Commonwealth has concerns about. Another analogy I would make, Your Honor.
I do have to mention Lally's hair, though. I'm sorry. I can't stop looking at it. What is with that? Like, sideways mohawk spike he's got going on. Oh my God. Oh, hey, Cup you. I'll probably get through the rest of these pretrial motions today. I don't know how long it'll be to get through these pretrial motions. If it's not too long, I'll start opening statements today. But if the pretrial motions are more than like an hour and a half or two, I'll probably wait till tomorrow to do pretrial motions. But I'll let you know in advance. If I don't do it today, I'll let you know in advance, Cup you, when the opening statements, I start them, okay?
Is to voting place restrictions.
His hair, though, is
fundamental
really
right in which
bugging
there
the
are
shit out of
restrictions
me.
as far as signage and footage away from the voting place of how close you can be, that they're not allowed inside the building with signs related to whatever specific candidate you're supporting. You can't go in the voting booth next to somebody, take your candidate sign and shove it in somebody's face
No
while they're
problem,
trying
Cup
to
you.
exercise their right to vote. Essentially, what this motion is asking is or seeking to protect is the freedom of the jurors who are called upon to execute their civic duty unfettered from extraneous influence. We're not asking the court to restrict the media or anyone's access to the media. And I would note anecdotally that within this courthouse over the last year plus, there have been several instances in which jurors on completely unrelated cases have had to receive instructions from the court and been impacted by the activities related to this case every time that it's on. Lastly, what I would submit to the court is really any opposition, or at least the ones that I've seen as far as an amicus, essentially, the reason for the opposition is because there are parties that want to try and see if they can influence the jury inappropriately in this case. All we're asking for, Your Honor, all the Commonwealth is submitting in whatever form or modifications the court deems appropriate based on the Commonwealth's proposal. But what we're essentially asking for is to allow the jury to execute their duties in this case, both during the impanelment process and throughout the course of the trial as they're hearing evidence, and not be subjected to extraneous influences, regardless of the viewpoint of those extraneous influences during the course of the exercision of that duty. For those reasons, the Commonwealth would ask that the motion be allowed.
All right. Thank you, Ms. Unetti.
Thank you.
Oh my God, that was hilarious.
Your Honor, I have three things that I would like to put on the record for this court. First, please note that we do not control these protesters. This has been an organic movement that arose because ordinary citizens were made aware of the case and apparently agree with us that the prosecution of Karen Read is unjust. Speaking out against injustice is a fundamental American right. My client is appreciative of the support that she has received and continues to receive, but we in no way dictate or instruct anyone to do anything. These are strictly citizens invoking their right to free speech. Second, while we question whether the Commonwealth's motion is constitutional, we are taking no position on this issue. In our view, this is between this honorable court and the general public. It is between...
And I share your view. I think this is something that frankly could have been done administratively. But I wanted to give the defendant an opportunity to be heard. So you're not taking a position on it?
No, we believe that this is between the Commonwealth and the Constitution, and in this honorable court and the general public, and that while the ACLU has filed something, members of the public have filed something, they will speak to the constitutionality of this. And other than receiving our sympathy and our blessing, we are not joining in their argument. Again, we're taking no position. And I want to make clear that our position, our intent is and always has been that we are going to win this case inside the courtroom. Your Honor, that is what we're going to do. We're going to win this case inside the courtroom. And with that, I'll waive further argument.
Okay. So I have received something styled a citizen's motion to intervene. And I think criminal counsel surely knows that unlike civil, there is nothing in the mass rules of criminal procedure that supports intervention in a criminal case. But I've read the memo. I received it yesterday and I've read it. I am not going to hear from counsel. I do want to say, and quoting the appeals court, intervention is a concept foreign to criminal procedure. Now, apparently the Civil Liberties Union of Massachusetts, understanding that, filed a motion to file an amicus curiae memorandum. So that motion is allowed. And I have read the ACLU brief, and frankly, I find it very helpful, and I've been persuaded by many of the points in there. So I don't need to hear from anybody, and the ACLU, I think, did a great job in their memo, and I understand their position. So it's undisputed that under our system of government, the people's right to protest is preserved under the First Amendment, as is the free expression of their views. I have to consider, of course, this very important constitutional right, but the bedrock principle of the trial court is assuring a defendant, it is and it must be assuring the defendant a right to a fair trial, which includes a right to a fair and impartial jury, which by definition is a jury free from any outside influence. So my focus has to be on having this jury hear the evidence and the law and decide this case based solely on the evidence and the law that is heard here in this courtroom. I have to balance the rights of protest. The law is very clear on this. Sometimes these are competing interests. But in balancing them, in weighing all the factors, I do find that an external buffer zone is appropriate and that we do need prudent regulation on in-court expression. But the 500 feet is far too excessive. So I recognize that my obligation is that I must reasonably accommodate the rights of all people to protest in a meaningful way, while ensuring, above all here, that this case is decided fairly based on the evidence without any undue interference from outside pressures or influence in accordance with the law. And that's what I will do. So I will have a written order and a very short decision on this by tomorrow, but hopefully by this afternoon. So I will see you all next week. And I intend to go through all the motions in limine on Friday. I would like council to consider how you want to do impanelment. If there is a request for a questionnaire, it needs to be a supplemental questionnaire. Council need to work together. It needs to be one side, one page, two sides, no longer. Council works together, and if you cannot agree on a questionnaire, then part one of the questionnaire will be what you agree to. Part two of the questionnaire will be what the Commonwealth wants and the defendant objects to. And part three will be what the defendant wants and the Commonwealth objects to. And it must all be on one page. So I'll see you all next Friday.
Thank you.
McLaughlin?
Good afternoon, Your Honor. David Yannetti for Karen Reed. With me is my sister, Attorney Tanis Yannetti.
Good afternoon, Mr. Yannetti. Good afternoon, Ms. Yannetti. Good afternoon, Ms. Reed. Okay, we ready to start? All right. So what I'd like to do, the order I'd like to go in is, first of all, the Rule 17 motion regarding Trooper Proctor. So we did receive, and it was docketed today, an appearance of Attorney Michael DiStefano. And in his response to the defendant's motion, he tells us that Michael Proctor does not object to the defendant's motion for an order pursuant to Rule 17, seeking records from the Mass State Police Internal Affairs Division. So he doesn't object to that, so that motion's allowed. Any comment, Mr. Lally?
No, Your Honor, I would just say that the Commonwealth also does not object. Spoken to legal counsel from state police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just a yes or no? And
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay, all right, so I'll hear from you then, Mr. Yannetti, on your Rule 17 motion, seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted out of this case at that point.
So I want to know where that is in the record before me, because I think you know, as Massachusetts counsel, that the state police have jurisdiction over homicides, correct?
Oh, they do, yes.
So where is it in the record that they were conflicted out?
Those are in reports that the prosecution provided to us. Mr. Lally also told me that orally early on in this.
Okay, so I need those reports. I need that reference.
Okay, we're happy to provide that. Judge.
Okay, so I'd like it by tomorrow morning.
That's fine, Your Honor.
Okay.
So the Canton police had a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the brother of one of their officers? It stands to reason they can't. They appeared to recognize that. Yet Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury. Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the recusal, the self-recusal of the Scranton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done but did not. We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right. It looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to provide them as well.
They're two separately filed motions, right? And
Yes.
One of them is with Mr. Berkowitz, or former Chief Berkowitz, but he's not on the other. So I saw them as two distinct motions, and the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. And I would note that the providers are on the second motion, except
But
for
that's three different people, or one different person on the second
one different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of 2023 to the present day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture, in regard to federal grand jury materials, which belie much of what counsel claims that they say. essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say is, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who, admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred, and continue to associate and be friends following this incident. Secondly, the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for, from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard on the Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so, out of an abundance of caution.
Okay, no, I understand you're following your order. I'm going to make it available. Not a party to any protective order. So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My apologies.
I'm happy to be heard now, and if the court will allow us to review the motion and the memoranda, we can amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Okay.
So.
Can I have one moment, Your Honor?
Yes.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address is dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have the court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So I think it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you. All right, so counsel, I need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
William.
Thank you. All right, I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case, and he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed by the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a Congressional Medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much. Counsel?
Good afternoon, Your Honor. Attorney Peter Paschuko on behalf of Kevin Albert.
All right, so you need to spell that last name.
Sure, it's
for us.
P-A-S-C-I-U-C-C-O.
Good afternoon.
Yeah. Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals. And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition. So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
Okay, thank you very much. All right, Mr. Yannetti, did you want to respond or no?
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them. And I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed. And it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins, but again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January 29th.
Brian Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th. That's what you're
That's
seeking.
fine. That's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay. All right, so go ahead. Thank you for answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're asking this court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury where he asked about all of the back and forth between him and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call from or with Berkowitz at 7:22 in the morning. This is on January 29th. Another call with him then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute, then another call with Albert for 10 minutes, then a call with Berkowitz for 4 minutes. Higgins spoke with Berkowitz on January 29th, someone who was conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We have a chief of police who's supposedly...
I'm sorry, I just need to, so at that point, you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by investigators yet, but clearly he's a witness. He was at the home that night. Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it, but somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records. which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right. Thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a discrepancy in the dates that I'm not really finding any support for within the context of the motion. So
that's why I asked. So
my question was a different one as to the dates, though. So
Okay.
when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to anything occurring. So I'm not sure why anything on the 28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
what do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third party counsel if they want to be heard.
Your Honor, if I may, just one
Sure.
further thing. I did speak with counsel. It's attorney Kenneth Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you. All right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, well, with respect to our general arguments, we'll just rest on what I'll rest on what I said previously. And we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right, and does counsel object to these records? Mr. Henning on behalf of Brian Albert? All right, and counsel on behalf of, oh, that doesn't concern you. Okay. All right. Thank you. Defendant filed, Mr. Yannetti, you filed a motion that I just got as I was walking out here.
Right. We're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's filed with a motion to impound as well. I figured I would hand deliver it today.
Okay,
The
great.
Commonwealth just got it today, so they'll need time to assess that.
All right, so today, all pre-trial, non-evidentiary motions have to be filed pursuant to
Yes.
the order.
Yes.
All right, so this is it? This is
No,
what the...
I expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week?
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California, Pro Hoc Vice. I don't know that it's necessary, but
I'm glad you filed it because I think it is if you're not here and you have to be here
that's
for
why we
that.
did.
So
That's why we did that, so.
Ms. Yannetti I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. I'm not asking for any action on it, but I believe that would be it.
Okay, and I have one question. Are we all done with Bodie Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday,
Sure.
where we are with that. All right, great. I'll see everyone Tuesday. Thank you.
Your Honor.
Thank you, Your Honor.
March 26, 9 a.m., hearing on all pretrial non-evidentiary motions.
When we were last here on February 26th, I first anticipated that today would be for all motions, but I did read the very detailed affidavit from defense counsel regarding dates and what we should cover. And so today, as you know, I changed some of the dates to accommodate you, I think there was some short trial dates you may have had or restitution dates. And so you did get the order on the new dates. So today is only for filing all Rule 17 motions and for the motion to dismiss under Odell and the motion for sanctions. So I don't remember if it was Mr. Jackson or Mr. Yannetti who last time said that I was operating from a blind spot because I didn't have the information that was disclosed to you folks from the U.S. Attorney's Office. So you were good enough to get me the entire packet, which I appreciate. I read it. I see now how the federal investigation began and when it began. I've also read the pleading. So the motion to dismiss, defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also, I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings." So I've read everything. I'm going to give each side 10 minutes, and we're going to start with the motion to dismiss. So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So go ahead.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
Yeah, all day. But that was when we had all the motions, but it's just these two motions
Right,
today.
but they're big.
They're
and there's
big.
consistent with.
Why don't you go ahead and start? If you need additional time, tell me. But it would be important to focus your argument. Again, I'm mindful of what the U.S. Attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
Which means that.
Right ahead.
I'll start with the basic rule of Odell. We start with the postulate that any distortion of the evidence, that's where we start. Any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say, your memo is very thorough and very helpful to me because you outline everything and same in your supplement.
Thank you. The first point I want to discuss is what we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They have a long-standing, years-long relationship. And I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least. And there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some sort. Michael Lank walks out of the same bar or an adjacent bar. He had been drinking with his buddy Chris. He walks out, stumbles out, announces to the participants in this fight that he was quote unquote deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E
That's
attached
right.
to your memo.
And the reason this comes to a head, and the conflict of interest comes to a head, is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury, nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and asked, the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury. Sergeant Lank is a longtime childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years-long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. And we've been rebuffed at every single turn. Newly uncovered text messages, but from the feds, revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
So yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts, to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody looked the other way. As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words, because we didn't create anything. And there's more. On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift. Michael Proctor didn't respond with, that's inappropriate, these are witnesses, these are potential suspects, please tell her don't ever do that again, don't ever suggest an exchange of gifts again, that would be inappropriate. I'm gonna go write a report, I'm gonna turn it over to Mr. Lally, and Mr. Lally's gonna turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife. In other words, get the gift from my wife, it'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February 1st, 2024, now let's fast forward 2 years later, now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA under very intense questioning that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Butnik, all of this before Yuri Butnik testified at the grand jury and before he and Butnik actually interviewed Chris Albert. Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Butnik testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Butnik knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression Michael Proctor, Yuri Butnik, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the Assistant United States Attorney, Proctor was caught in his own web of deceit and testified as follows, quote, this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means that evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so your time is up, which includes me interjecting. Do you want 5 more minutes?
If I could
Yeah.
implore the court.
I'd like you to sort of get to the questions I asked as well. All right, I know you're reciting the evidence that I've read, but so I'll give you 5 more minutes. Go ahead.
Thank you. I want to shift gears to another example or another series of examples of evidence that was distorted before the grand jury. And that deals with the use of or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert and the fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert, when that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault. Certainly not Ms. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job in extracting. And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 and 40 seconds a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate. And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion from the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury and the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust, the ones that are supposed to protect our interests. And the law does not allow this sort of conduct to go unchecked. When the remedy, when this sort of travesty of justice occurs, is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and and Mr. Lally are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance, I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right, thank you. Mr. Lally, we're going to start with 10 minutes. If you need more, you need to tell me.
Sure.
And thank you, Your Honor. No, I think 10 minutes should be fine. I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as brief as I can. Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation on the McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of three elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And three, that the evidence probably influenced the grand jury's decision to indict. None of which I would submit the defendant has met their burden with reference to any of those three elements. Just addressing sort of the overarching themes of the defendant's motion. The defendant challenges, as he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a purported deception of Sergeant Lank's relationship with the Albert family. Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with the Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard at the time that Mr. O'Keefe is found. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card money trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcripts, which clearly demonstrate and indicate that the defendant, Karen Reed, killed John O'Keefe. But they don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised. In reviewing the materials provided by the U.S. Attorney's Office, a couple things that I would note is, number one, they have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea. The other part that's confounding is that it appears that these materials or materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear from the investigation that they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Ms. McLaughlin stated on the last date, that these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians' witnesses' testimony that we've received, or transcripts of that testimony. All of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight. There was no dog attack. There was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent a year later. They testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear definitive statements on scene, that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home on the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to texts from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for two no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided childcare in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened. Lastly, get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate. But I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing. Essentially, what we have is, yes, what counsel mentions is there is one expert who was given two extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of those, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that. But based on the totality of the evidence and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay. Do you want a few minutes, Mr. Jackson, to respond?
Very briefly.
Okay.
First of all, it's always interesting to hear an argument that suggests there's nothing to see here. That's exactly what Mr. Lally did yet again. He said, look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. The fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. Doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him and he wasn't hit by the car. Period, full stop. That's their independent expert, not ours, not somebody on our payroll like Mr. Whiffen or one of their experts or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally, that car did not hit John O'Keefe and John O'Keefe was not hit by that car. But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these 2 texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were, in fact, in communication with each other as early as 2020. And with regard to the 2:27 a.m. search, it's not a 3-card Monte. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember. What they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well. All 3 of those searches existed in the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of a proceeding. He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it, deny this motion. We're talking about the integrity of what is the foundation of Massachusetts judicial system. and that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right. Thank you very much. Ms. Giannetti, are you all set?
Yes, Your Honor, thank you.
So the same time, and let's see how you do with it.
We believe our witnesses. They are telling the truth. Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey to potential jurors in this case on that date. I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal as a result of his
So
egregious.
can I just interrupt there and ask you, are these going to be the same motion essentially?
No. There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue, Mr.
No,
Kennedy.
it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that. But even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right. So when you file the other motion, I need you to include in your memo how that's different specifically from this.
Understood.
Not just the remedy, but how the basis of it
Understood.
is different.
Understood.
All right. So I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023, and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements. By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County, not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never in over 30 years of practice have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence. And I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting, they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, his office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
Probably about 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you. Indeed, Your Honor, Justice Jackson practically spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interviewed. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Reed convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done. DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Reed is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end. The DA also, as my colleague has indicated, I'm sorry, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time. There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice with no vested outcome in this case. And it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case. And that is why I urge you to do just that in the interests of impartial justice.
All right. Thank you very much. Who's arguing this? You, Mr. Lally? All right. So let's start with 10 if you need more.
Thank you, Your Honor. And again, I don't think I'm going to need much more than that. Again, I know the court has reviewed all the materials, and I know the court is well aware of their standard, and it's a standard which I would submit just simply hasn't been met here. To characterize counsel's actions in this particular proceeding with specific reference to the media and saying it's different, I think is minimization to the highest degree. Essentially, what the defendant is positing, or what counsel is positing in this motion, is that due to a recorded statement by the district attorney over 6 months ago, that impinges on her right to a fair trial, or it impinges, shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. It's also in conformity with Rule of Professional Conduct 3.6c, which allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again, I know the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated that the statements of counsel arguably crossed the line of permissibility under Rule 3.6, and that meaning defense counsel. That the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case. And that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media. And going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time. Denying it without prejudice. And then Mr. Giannetti wants to get up here and say that they largely stopped making extrajudicial statements after the court's ruling. And so I guess largely stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Giannetti and Mr. Jackson were featured for a 9-minute, 37-second segment, in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think the confrontation got physical and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on to continue that this was a cover-up and indicating that John was murdered inside that house, his body was placed outside. This also continued into September. September 17th, the defendant traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer to the victim's home, to Mr. O'Keefe's home, in direct violation of her conditions of release, where she has to stay away from, as well as other places of interest and sort of tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements, those particular actions go, as the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Reed on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023. And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the district attorney's office, the state police, So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous. Disingenuous would be about the nicest term that I can come up with for that. Thank you.
All right. Mr. Yannetti, a short rebuttal, I guess, or a short comment.
I would just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that, I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones in your
I
motion?
believe
with the
they're
continuance?
outlined. Yeah, they're outlined, Judge.
Okay, I asked because Mr. Roach told me that on the March 20th date, the council wants it to be via Zoom. I'd prefer it not be, because with Rule 17, as you know, the record holders come into court and object. So I don't want you all to be on the screen. And Mr. Yannetti, certainly your local counsel. Mr. Jackson, if you want to be on the screen, you can. But I need somebody here.
I understood you, Ron. That's fine.
Okay?
That's fine.
It makes sense to me.
Yeah. If I may just...
Yes.
Can I appear in person and have my client join me?
No, she has to be here.
Okay, thank you, Judge.
All right. Was there something else? Yes.
I would ask, may we approach just as the scheduling issues?
Okay. All right, you had a question, Mr. Jackson?
I did, Your Honor, just about the logistics of the trial, meaning days in trial, half days, 5 days a week, 4 days a week. I wanted to get some sort of sense so we can begin planning.
Okay, so we're going to go full days, Monday, Wednesday, Friday, half days, Tuesday, Thursday,
Are the half days afternoon or half days morning?
mornings.
Okay.
Okay, anything else right now?
Can I have one moment? No, Your Honor, thank you.
All right, anything from the Commonwealth?
No, Your Honor.
Mr. McDermott?
Judge, I just wanted to put on the record that I think I provided to everyone copies of that letter from Google. I just wanted to make sure, just put that on the record that I gave you copies of that. Thank you.
We received copies.
Great.
All right, great. All right, thank you very much.
Thank you, Your Honor.
Thank you.
All right, we're going to finish one more pretrial motion and do some opening statements sometime tomorrow. Bye.